The last exception that we're going to cover, the last exception to the hearsay rule, is the residual exception, which is now located in Rule 807. So the history of this exception is really interesting. In the original exceptions that were in the original draft of the Federal Rules of Evidence, they were much broader than the final rules we ended up with, which were originally located in 803.24 and 804b5. The original rules were the source of a lot of angst and complaining by the litigators, actually, during the first comment period on the rules. So, in the end, the advisory committee really changed the originally proposed rules a lot and watered them down in this context, the residual exceptions. But looking at the current Rule 807, which you see on the slide, sections A3 and A4, and the notice requirement that's in B, those were all added to the originally proposed rules after all the lawyers complained. But the residual exception still contains this strange idea here in A1 that a piece of evidence can somehow have, quote, equivalent circumstantial guarantees of trustworthiness as the trustworthiness contained in the conglomeration of exceptions in 803 and 804. And after all, the exceptions in 803 and 804 don't have anything in common with each other. And here in B, it contains something completely different from all those other exceptions, and that is this notice requirement. So unlike any other hearsay exception, you're going to have to give the other side notice that you're going to try to use this residual exception to get one or more statements in, along with the additional requirement in the federal system of giving the other side the declarant's name and address if you have it. So it's hard to know, looking at Rule 807, how it might be used. I mean, certainly, I'm sure when you looked at it, you thought, wow, this kind of seems to give judges an awful lot of discretion to let in hearsay statements. So it seems to provide a pretty big opportunity for a judge who might be inclined to let in a hearsay statement to do so under this rule just because she wants to. So you read the ABA excerpt in the book after the Turbeville and Zenith cases. That was written in 1983, and it talks about the fact that up to that point, there were about 50 reported decisions per year from 1975 to 1983 in which judges used this hearsay exception or actually at the time, right, there were two hearsay exceptions, one in 803 and 804 that were residual. That article also mentions the fact that the courts that have done it and used it seem to always talk about how we know this rule should only be used very sparingly in unusual situations, and then the court goes on to say, and by the way, this is one of those unusual situations, and that's why I'm admitting it here. The other thing the article makes clear is that this exception has been used haphazardly, really unpredictably, so it's hard to categorize in any way the kinds of statements that are most likely to be let in, aside from the data the article cites that show that it's used way more in criminal cases than civil cases. So here a lot's going to depend on how the jurisdiction and the individual judge views it. So this very strange catch-all hearsay exception in Rule 807 does seem to really take the teeth out of the hearsay exceptions we've been trying to sort through and start to memorize, and does seem to give judges the discretion to admit hearsay that they really just think ought to be admitted. In the book, you skimmed this Turbeville versus International Harvester case. I think of this as a classic Darwin Award case. You can look up the Darwin Awards if you don't know what that is. But so this case ended up in federal court on diversity grounds, and the facts are kind of garden variety, really stupid guy behavior that often leads to tort suits. So the plaintiff and his two buddies here went to the defendant's used car lot to buy a truck. And they picked one that particularly interested them, but then, it wouldn't start. So that's embarrassing to the guy trying to sell the truck. But now all these guys are trying to get the truck started, right? The plaintiff, his friends, and then one of the defendant's mechanics, Oakley Anderson, was helping them. Nothing was happening though, and then the plaintiff had the brilliant idea to pour gasoline from a little can directly into the carburetor of the truck while his buddy tried to start the engine. Then the engine backfired, ignited the gasoline, which of course seriously injured the plaintiff here. All right, so the crucial bit of evidence that makes the case interesting came up 3 hours later. So Oakley Anderson, his supervisor, heard about the injury. He later claimed that he instructed Anderson, go into a room, fill out a statement, don't talk to anyone else, just write down anything and everything you know about the accident. And then Anderson made this handwritten report that is the subject of the case, which not surprisingly blamed the plaintiff and his buddy for the accident and not Oakley Anderson himself or the company. But unfortunately, by the time of trial, Anderson had died before he could testify in the case. So prior to trial, the defendant here moved in limine to allow Anderson's written statement into evidence under the residual hearsay exception, which was then located in Rule 804b-5. And the judge granted the motion, the statement came in, and the jury ended up siding with the defendant. But the plaintiff then moved for a new trial, arguing admitting the statement was an error on the part of the judge. So what we have in the book is actually the judge's opinion and order denying the motion for a new trial here. So not an appellate opinion, just the judge justifying his decision at trial to use this hearsay exception to let the statement in. So obviously the evidence here was hearsay. It didn't fall within any of the traditional exceptions to the hearsay rule. The statement wasn't an excited utterance because there was no evidence that Anderson was excited at the time he made it. It wasn't a contemporaneous present sense impression because of the 3-hour time lag. The statement would have been admissible as a past recollection recorded if Anderson had survived long enough to testify that his account was correct and that the items were fresh in his mind at the time he wrote it. But he didn't survive, so there was no way to lay the required foundation for that exception. And then lastly, the evidence could maybe have been admissible as a business record. We saw in that Lewis versus Baker train case how the court there did let in the record created by the plaintiff's co-workers after the train engine accident, even though that earlier Palmer versus Hoffman railroad case from 1943 would have seemed to dictate that it not be let in. But in Turbeville, the court didn't try to stretch any of the traditional hearsay exceptions, instead just ruled that it had properly admitted Anderson's statement under the residual hearsay exception. So I have this quote from Judge Joyner from the middle of page 473 on the slide. Maybe you could pause the recording to read it right now. But after reading the statement, it's not hard here to argue that Turbeville just sort of kills off the hearsay rule as a kind of evidence. I mean, if Oakley Anderson's statement is admissible, a lot of other kinds of arguably, quote, reliable hearsay evidence should be admitted too. So it's hard to discern really what made this evidence so special. Even though it is true, as the court pointed out, that the statement was written while the event was fresh in Anderson's mind, that's true of an enormous amount of other kinds of hearsay. And what about the fact that he was supposedly alone while he was writing it, supposedly not prompted by his superiors? I mean, that seems more dubious, considering that at the time it was certainly possible that Anderson himself might have ended up as a defendant in the case. Plus, he was writing the account of the accident on behalf of his employer. So obviously, we would think that he would have motivation to make his employer seem not responsible for the accident. So I don't understand why the court thought here somehow this statement was particularly especially reliable. Nevertheless, the Turbeville decision is really in your book to warn you, apparently, that this kind of thing shouldn't surprise you if it occasionally comes up later when you're practicing law. The residual exceptions have been used many times since the adoption of the federal rules of evidence, although more for criminal cases than civil. This is the kind of thing that law professors love to write articles about, including arguing maybe we should dump all the delineated hearsay exceptions and just leave everything up to trial judges to admit it if it's reliable. And that's not the way our hearsay rules have traditionally worked. In fact, The hearsay exceptions are sort of in there to kind of cabin the power of trial judges, even though there's some discretion, like when there's a duty of the judge to decide some of those complicated preliminary questions under Rule 104A. But this concept of just dealing with hearsay through discretion of judges presents the two problems that I have on the slide, at least. First, in many parts of the country, a high percentage of trial judges wouldn't be able to fairly and rationally apply discretion like that. Appellate courts can't and shouldn't trust a lot of judges, especially elected state judges, to separate reliable from unreliable hearsay. So allowing a discretion standard would make the appeals process a lot more complicated because the appellate courts would have the burden of policing trial judges' performance. Certainly seems like it would be unworkable. But the other problem is putting all this power in trial judges to admit hearsay. It's going to completely destroy predictability in litigation, which is going to make settling cases a lot harder. And this is hugely important to a legal system like ours, where at least 90% of the cases are settled. So it seems like this was a major factor that led Congress to reject that originally very broad discretionary exception that was originally proposed by the advisory committee. But even with the addition of the clarifications in the rule and the notice requirement, for the most part, Congress left it up to federal judges to figure out the details of the residual exception. And it seems like, with the exception of judges like Becker in the Zenith case that we're going to talk about in a second, which was ultimately overruled, judges have seemed to move, at least in some cases, toward a more liberal position in the use of this rule. So Turbeville, one example among many of what is actually happening in the development of the residual hearsay exception, even if there's no way of predicting any sort of pattern. Okay, so let's just talk briefly about Ed Becker and the Zenith case on page 474. So this case is in here to talk about this idea of a near miss question, which is the issue of whether the residual hearsay exception should be applied to a statement that is generically of a type covered by a specific hearsay exception, but that just doesn't quite satisfy all the requirements of that exception. Just sort of barely misses it. So Judge Becker here put a lot of energy into thinking about this issue. He concluded that, wait a second, the residual exception should actually not be allowed to be invoked when there is a specific exception in the rules that governs a clearly defined category of evidence, if the evidence at hand would properly be judged under that more specific hearsay exception, and if it doesn't meet all the requirements, and then it misses under the exception that it should actually fall under. And in Zenith, Becker held that the evidence presented by the plaintiffs that would normally fall under the exception for former testimony, that one in Rule 804B1, Becker said, look, that shouldn't get in if it doesn't meet the requirements of 804B1, because that was one of the exceptions that was quite specific about the kinds of statements it covered and what the requirements are. And Becker says, look, in cases like that, the assumption should be that Congress clearly did not intend for evidence that didn't meet the requirements of the rule to sneak in through the back door of this residual exception. But then he goes on to talk about the fact that most of the exceptions that the plaintiffs were asking for here in Zenith applied to a relatively amorphous category of evidence, which is delimited solely by the requirement set forth in the rule itself. And in Baker's opinion, if a statement didn't fit the criteria of one or more of those more amorphous exceptions, then maybe it should be considered under the residual exception. So again, Becker is advocating dividing up the hearsay exceptions into two categories, either amorphous or clearly defined hearsay exceptions. And if a statement falls under one of those clearly defined rules, like 804B1, and just almost meets the requirements, then it shouldn't qualify for residual exception admission. So that's all a very interesting academic exercise that Becker went through in the Zenith case, but we have to note that Becker was overturned on appeal. His formulation of this near-miss approach has actually not been accepted. In fact, For example, other courts actually have admitted former testimony that didn't meet all the requirements of 804b1 under the residual exception. So again, even though this near miss doctrine is kind of interesting, it hasn't caught on. Okay, so the last 803 exception I'm covering is the ancient document exception in Rule 803.16. I think this is a really good one to test on because it's sort of easy and straightforward. 803.16. So the basic idea here is that admitting statements from a document prepared by someone years and years ago that predates the current case or controversy is relatively safe. And so statements in these documents are thought to be more reliable than other writings because the writer presumably didn't have a motive to lie when making the document. So again, a great testable point. So look in exams or the bar exam for documents under the federal rule that are at least 20 years old. Documents that are at least 20 years old. We have a similar rule here in California, but we are stricter. In California, a writing has to be at least 30 years old to get in under our ancient document exception, not just 20. And then actually in California, we add an extra guarantee of trustworthiness requirement. So we say in California for a statement in an ancient document that is at least 30 years old to be admitted under this hearsay exception, there has to be evidence that people with an interest in the matter affected by the statement actually acted on the statement in the past as if it was true. So I just wanted to talk briefly about this hypo on page 480 of the book. Maybe you saw it. So here it is. A plaintiff offers in evidence a 19-year-old written inventory of personal effects. The judge concludes that the inventory was not prepared for the present litigation, and that it is better evidence of the facts stated in it than the memory of witnesses who, about matters that happened so long ago. May the judge admit the inventory in evidence under the residual exception to the hearsay rule. Okay, so basically this hypo is purposely saying the document is 19 years old, so it doesn't fit under this ancient document exception in the federal rules, because remember 803.16 requires documents to be at least 20 years old. So there's two opposing arguments, I think, in this hypo. So on the one hand, when Rule 803.16 was drafted to let in statements from documents solely because of the age of the document, there was an actual clear cutoff, which was 20 years. So you could say that by negative implication, documents that are under 20 years old should be excluded if that's the only hearsay exception that would let them in, is age. Certainly under Ed Becker's near miss doctrine, he'd probably consider this to be a very specific rule. So he'd say this shouldn't qualify for the residual exception. But again, we know that doctrine didn't hold sway and his case got overturned. So the hypo says that the judge has concluded that the inventory is better evidence of the facts stated in it than any other available evidence. So, the judge has already said it makes it over the hurdle here in 807A3. But what about 807A1? The question is, does it have equivalent circumstantial guarantees of trustworthiness? So in the hypo, there really isn't any information given about the particular reliability of this inventory. We just know that it wasn't prepared for the litigation, and there aren't any available witnesses that could testify from memory about the inventory, so it's the best thing that can be offered in the case. So maybe if the proponent here could set forth additional reasons to support reliability, something beyond the basic, oh, it's almost 20 years old, and it's almost an ancient document, therefore it's close, so to get in. There should be something beyond that to say why it's reliable to get in under the residual exception. So for example, let's say the proponent could point out, after all, this document was prepared by a person with no motive to lie while his memory was fresh, or something like that. If there was some proof of how the document got drafted, maybe that would be enough for a judge to actually let it come in under the residual exception here. So the last thing I do want to say about the residual exception for your purposes, on an exam essay question, if there is a hearsay statement that you think might qualify for admission under the residual exception in Rule 807, you could mention it. But if you do, you should definitely show me that you know what the threshold requirements of the rule are, in particular, this equivalent circumstantial guarantee of trustworthiness and the more probative on the point for which it is offered than any other evidence that's available, and maybe throw in that it's going to serve the interests of justice. So don't just throw in residual exception. You should actually say, especially that there are equivalent circumstantial guarantees of trustworthiness and why that is, and then why it's more probative than any other evidence a proponent can have. All right, that's it.